I think what we can expect is, if history is any guide, that affirmative civil rights litigation will decline, at least as it's initiated by the federal government. From the outset, it was very important to me and my colleagues that we make clear that the class wasn't about bashing Trump's policies, nor was it about defending Trump's policies, if that's what students wanted to do. It was about understanding the legal framework in which the policies took place, and in which challenges to the policies took place, and in which defenses of the policies took place. We wanted to focus students on just what the executive can accomplish on its own, and when the executive needs the cooperation of the judiciary, when the executive needs the cooperation of the legislative branch to accomplish its goals. The reason we're focusing on Trump's first 100 days, to be precise, is because he's an unusual president. He comes to the office with an unusual background, and he promised in many ways to upend some of the traditional ways that we do politics. And so there was an idea amongst my colleagues and I who created the class that students wanted to better understand the limits of any presidential administration, but particularly the limits of the Trump administration, given all the promises that he'd made on the campaign trail. The pattern that has existed is when Democratic presidents have been in power, in office, affirmative civil rights litigation by the federal government has increased in general. When Republican presidents have been in office, it's decreased. But the other reason that we should expect this kind of litigation to decrease is because Attorney General Sessions has been hostile to it as a senator over time, so we would expect, now that he's the Attorney General, that he also will be hostile to it.